Good morning, all. This trial is in the matter of CFI 070-2024 before His Excellency Justice Thomas Bathurst, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Nasser H. Bajamal Limited. Lead counsel is Mr. Amr Bajamal, and the defendants have failed to appear. Thank you, Your Honour.
Mr. Bajmal, the defendants, of course, are aware of the date of this hearing and have indicated they don't wish to appear, so there's no difficulty with proceeding. Would you agree that, notwithstanding their non-appearance, I have to be satisfied on the material available that your claim is made out?
Correct, Your Honour. That's why I was planning to still take Your Honour through our opening statement this morning, and also we do have the witness available in case Your Honour has any questions for the witness.
Thank you.
So yes, we are ready to go.
What you propose to do is, in effect, walk me through your skeleton argument.
Yes.
Thank you.
Thank you, Your Honour. So, Your Honour, I'd like to start with some background facts. So, our client, the claimant, is a provider of solar energy plants and power. The first defendant, is a company that runs a glass manufacturing entity out of Jebel Ali in Dubai. The second defendant is an affiliate of the first defendant who has provided a corporate guarantee to secure all the obligations of the first defendant under the lease agreement. There are three primary documents in this case. The first document is what is called the solar photo. It's called, my apologies. The document title is called the Solar Photovoltaic System Leasing and Operation Agreement, which I will refer to as the lease agreement. And then we have a document which is called the amendment agreement. Now, the defendant refers to this as the financing agreement, but I'll come to that. And the third document is the corporate guarantee document dated the 30th of June 2021. Which was signed by the second defendant. Now, the role of the second defendant in these proceedings is limited to the claimant asserting that it should be liable for all the amounts that the defendant is liable for. And there is only one defense that the second defendant has advanced, which is a defense that alleges that the guarantee, so the second defendant essentially accepts and acknowledges that it is liable under the guarantee agreement, albeit there's an argument that it should not be liable for any amounts arising from the tri-party agreement, because it contends that the tri-party agreement is a standalone document, and I'll address that during my...
Let me just ask you this. The tripart agreement is separate, of course, to the three agreements to which you've just referred.
The tri-party agreement is separate, but what connects them is the amendment.
I understand what you say, but the defendant, in effect, is saying, the second defendant's case is in effect that it's not liable for anything under the second agreement. Is that a fair summation?
Because the agreement with Matrix is because Matrix was the supplier for the waterproofing system. So the claimant agreed to make payment on behalf of the defendant.
Understand that.
Yeah. So, but what brings the second defendant liability into the picture is the amendment agreement, because under the amendment agreement, the first defendant became liable to pay the consideration amount, and the default subsequently, and therefore we say that since the guarantee guarantees everything under the main agreement, then any amendment also covers all the obligations under the main agreement, because it becomes part of the agreement.
I understand your argument, and no doubt you'll develop it shortly, but it is the one aspect, one of the aspects, or the principal aspect, I should say, that concerns me. I understand that the document says it's an amendment to the lease agreement, but whether in truth it can be characterised as such, notwithstanding what the document says, is what I think the liability of the guarantor for that amount hinges on. That seems to me to be the most substantial issue in this case, quite frankly, Mr.
Right. I will address this. That's actually the first issue in my skeleton. So I'll take your honor through it. Right. So the facts are known to your honor, as they can see. So I'm not going to go deeper into the simple point is that the claimant performed its obligations. The system became operational, and then the first defendant failed to make due payment on rent, which led to the claimant terminating the contract and claiming all the amounts that are due contractually upon termination. So as I pointed out in my skeleton, there are 6 issues that Your Honor need to consider today, starting with the first issue being whether the amendment agreement is a standalone document or a document that amends the lease agreement. Now, on this point, I'd like to take Your Honor to page 217 of the bundle, which has the amendment agreement. Now, following the arguments that were made by the defendant, the first defendant and the second defendant, in their defense, they contend that this agreement is a standalone agreement, and therefore it cuts the tie that is the corporate guarantee between the second defendant and the claimant. Does Your Honor have the document?
I've got the document in front of me, yes.
Thank you. So if we look, we say that on the face of the document, it is absolutely clear that it is not a standalone agreement, because if we look at the title, it says Amendment Agreement Number 1. Secondly, if we look at the preamble section at paragraph A, it says lessee and lessor signed the solar photovoltaic system leasing and operation agreement for Tajir Glass Industries. Terms used but not defined here shall have the same meaning as in the agreement, that is the lease agreement. And then in B, it says lessee and lessor hereby agree to amend the agreement in order to refer to the lessee's agreement to finance the waterproofing. And then if we go to provisions and then clause 1, we again see, in consideration of the matters described above, the parties hereby agree to amend the agreement as follows. And then there are 2 clauses that are inserted by way of this amendment. And then if we go to clause 2, it expressly says this amendment agreement amends the agreement and must be read together with the agreement and constitute a single contract. So
I understand all of that. What does trouble me, however, is, and I know the guarantee says the guarantor will be liable for any variation, which probably would get you there if it was a matter of construction. The guarantee did extend to this agreement. I don't think it's a case where the whole guarantee will be avoided, although that did trouble me at one stage. But the fact of the matter is that and I just want to put this for your consideration, the original guarantee, if you could go to it, I've been working off page 79 bundle. It's a guarantee of each and every sum which the lessee is liable to pay to the company under the lease. That's referred back to the lease agreement between the company and Alitair Glass of the 27th of June 2021. So that's what I'll call the primary obligation was. Now, the amendment agreement didn't really in any way, one sense, vary the term of the lease. It provided for a periodic payment of the waterproofing charges under 1C. It admittedly incorporated terms of the lease. There can be no doubt about that. But the real question is, I think, not whether the first defendant's bound by those terms, but whether the guarantee extends to that. And that's where I'm saying to you in substance, whether the agreement, notwithstanding those words, is really a separate agreement incorporating some of the terms of the lease, which is binding on the first defendant and your client, but which doesn't extend to the guarantor. That's the issue that troubles me.
Yes, but if we look at the wording, Your Honour, of the guarantee at A, so that's at page 79 itself. So it reads as follows. In consideration of the company entering into the lease, the guarantor as primary obligor hereby irrevocably and unconditionally guarantees to the company that if the lessee, if at any time and from time to time the lessee fails to make due and punctual payment of any of the balance of any and every sum which the lessee is liable to pay the company under the lease. So the reference to every and any sum here that means that the parties intended that it is not only for rent payments, but for any sum that becomes due under the lease. And the consideration amount, because it was incorporated into the lease agreement, becomes an amount that is due under the lease.
But they're the crucial words, whether in fact, for the purpose of considering the guarantee, this money was payable under the lease. Now, it will be, take this example. Let's suppose that the first defendant borrowed a couple of million dirhams or any sum for the purpose of carrying out a separate property development agreement. I'm just property development. And the party said, well, let's say for the purpose of attracting the guarantor, they said the payments were to be made under the lease. Would you say that would extend in those circumstances?
It might and it might not, depending on what the parties intended. But I believe in this context, it should, because the waterproofing system is an essential component of the solar power system. So without the solar power, there would have been no lease. Yeah, without the waterproofing, there would have been no lease. And therefore, in this particular circumstance, I believe it cannot be separated.
I'll look at this myself, but do you accept that the guarantee is to be construed contra preferendum to the guarantor? To the surety?
Can you repeat the question, Your
Honor? Do you accept that the guarantee is to be construed contra preferendum to the surety?
That is the general principle, correct?
And there is, of course, a line of authority, both certainly in the United Kingdom, which talks about the principles when what's expressed as a variation to the agreement is in effect a new agreement. Do you accept those authorities will be relevant to the determination of this question?
Well, the position that we presented in this skeleton is that in the DIFC, the most recent authorities suggest that one cannot incorporate English law principles unless they have a statutory basis in DIFC law. And the applicable agreed law in this case is the DIFC law. So unless there's a statutory basis, we say that we cannot incorporate English law principles.
But notwithstanding that, I have to be satisfied, do I not, that the the amendment agreement is in fact a variation, not a new agreement, for the purpose of determining liability under the guarantee.
You do, Your Honour, and we say that on the face of the document, there's enough to satisfy that requirement, because it is a document that inserts clauses into the primary document. There's no doubt about that, as you correctly mentioned. However, I do understand that in terms of the construction of the guarantee itself, that you don't need to be satisfied that the parties intended for every payment under the lease to be, because under the lease you would have rent and you'd have the purchase amount, which applies upon default.
Do I have to be satisfied objectively that the guarantor would have intended its guarantee to extend to this form of agreement? It's always a matter of construction, looking at the words.
Correct, Your Honour. However, I would say that the court should also be should do that within the boundaries of the defence that was advanced by the second defendant. And the defence that was advanced by the second defendant was purely on the basis that the amendment agreement is a standalone document rather than an addendum. So our view is that we need to remain within the defence.
I accept that. One thing, just going to the applicability of common law, my understanding was that common law could be used to the extent that the matter wasn't covered by the DIFC law, expressly covered.
Well, there has been a bit of a back and forth on this point in the DIFC, and we've provided, Your Honour, if you look at paragraph 59 and paragraph 60 of the skeleton, we've provided, Your Honour, with what we believe to be the most recent authorities on point, and these are Roberto's Club LLC and RELA from 2013, and then the most recent one was the Industrial Group Limited and Abdulazim Al-Sheikh. That's from 2022, and the general idea in these authorities is that if a matter is provided for in DIFC law or authorities, then in order to look into to expand on such principles, one can look into English precedents. However, if a principle or a rule is cannot be found in DIFC law or authorities, then one cannot refer to English law principles. That's the position as I understand it.
I suppose, going back to it, the guarantee is after all a contract, which means the DIFC contract law will be relevant in considering the interpretation.
That is correct.
That probably. Yep, thank you.
So on this basis, we say simply that on the face of the document, one should not look any further in terms of assessing what is the standing of the addendum. I'll move on to the second question now, which is whether the first defendant is liable to pay rent. Perhaps before I do that, I would like to summarize the different buckets in the claim amount that we have. So we have three main buckets and two subsidiary buckets. So the first amount is the amount of 985 874 dirhams, and this is an amount that is due for rent. And then we have the sum of 700,217 dirhams, which constitutes the unpaid consideration. So that is the remainder of the amount due for the waterproofing system. And then we have the third bucket, which is the amount of 8,140,436 dirhams, and that has two components. One is the purchase price, which operates as under the mandatory purchase provisions of the lease, and then we have the default value, which comes from the amendment agreement. Now, in connection with these three amounts, we claim interest at 6% based on provision 4C of Exhibit 4 to the lease agreement. And then we also claim...
What page is that in the bundle?
Is that the interest component?
Yeah.
Yes.
Exhibit 4, is it?
It is
I was looking
190. It is on page 190 of the bundle. Yeah, I'm going to address that in the next few minutes, Your Honor.
Oh, fine. Well, that's fine.
Yeah, thank you.
You go ahead.
So the two subsidiary components are interest and VAT. Now, going back to whether the first defendant is liable for rent payments, we do have a clear contractual provision, that is provision 4A of Exhibit 4 of the lease agreement, which expressly says that rent is defined as an amount that is equal to the electric energy generated by the system as measured by the meter installed by the claimant pursuant to Section 12 of Exhibit 4 of the lease, multiplied by...
Where do I find that?
My apologies?
Where do I find that?
Yes, this is on page 157 of the bundle.
Yeah. Thank you. I got that. Yeah.
Yes. So this is the provision that outlines the formula. So the formula is like any energy consumption mechanism, is simple. It's consumption multiplied by an agreed tariff. And then if we look at the witness statement of Mr. Longet, he explains the entire process of how the system operates. And again, it is quite straightforward in that sense. The process he explains in his witness statement refers to an exercise under which the meter, there are two meters installed on the property. So one is the claimant's meter, and the second is the government provider's meter, DIWA. And the way these systems work is that you sometimes have power coming from from DIWA, from the government provider, and you have the claimant's power coming to supplement that. So
where do I find the explanation, Mr.?
So the explanation is at 167 to 193. And then you don't have that?
167, that's the provision of the lease.
My apologies. I will find the correct one. So this is in paragraph 35 of the skeleton, and the references are there. I'm just going to find the correct page on the witness statement.
Page 393.
393. This has the pictures, which I'll take it on through now. So the process that he explains is in. I will find the reference right now. So it starts on page 138 of the bundle.
Yeah.
Yes, and then it goes on. It goes on, and that is the description. So to summarize what Mr. Longest testified is that at the beginning of the installation process, the claimant, in conjunction with the first defendant, take pictures of the meter readings, and then at certain following intervals, similar readings are taken again. So if we go to page 393 of the bundle, we will see, so 393 and 394. These are the pictures that we rely on in terms of the meter readings, and these we say translate into the amounts that we claim in terms of the rent. What also Mr. Longet explains is that the second reading, which is on page 395 of the bundle, this is the reading from the government's meter, and then the difference between the two, he explains, is very marginal in terms of industry technical practices. So it is within acceptable means. However, so the point that was put forward by the only defense that was put forward by the first defendant on this point is that the claimant is put to strict proof as to the fact that it did generate the power that it says it did. And we say that this is collaborated by way of the government's own meter, because if there is any suggestion that the claimant's meter's reading is wrong or manipulated in any way, then we could not have manipulated DEWA's meter, which shows very almost identical readings. That is the only defense that was put forward really by the first defendant. The other point that was put forward by the defendant was whether the claimant satisfied its obligations to maintain the system pursuant to the agreement. And our simple response to this is that the first defendant failed to produce any evidence that it ever complained of any problems with the system, and therefore maintenance is an ongoing.
There's just no evidence to support that proposition.
Sorry, I didn't hear that,
Oh, sorry, there is just no evidence to support that proposition.
Correct. And also Mr. Longjet's evidence stands uncontested because we don't have a rebuttal witness from the first defendant. The next point I wanted to address, Your Honor, on is that there was a contention by the first defendant about a certain number of invoices, and you'll see these on paragraph 40 of my skeleton. So to give Your Honor context, there are 4 invoices which are numbered 482, 483, 595, and 775, which can be found on pages 257, 259, 261, and 267 of the bundle. So the first defendant's argument is that 2 of these invoices are duplicates, that they relate to the same period of the first two invoices. And we say that this is simply not correct, because the first two invoices relate to a period specified within a period that falls within the rent period. Now, in order to understand what the second two invoices relate to, we have to understand what is the concept of outage under the lease agreement. So, pursuant to the lease agreement, the first defendant was under an obligation not to switch off the system for more than 24 daylight hours. If the system is switched off for more than 24 daylight hours, then the claimant is entitled to charge what is described in the agreement as the outage rent. So it's a simple equation that protects the claimant from having supplied the system and incurred the value of the investment from the system not being used to the detriment of the claimant. So there was a period during which the system was switched off, and this was communicated to the claimant, and therefore by way of an email. And these two invoices relate to this outage period, and we say that the outage, the right to charge the outage rent, stems from the express provision of provision 8G1 of the lease agreement. So it is simply rent for that period, but not for, it's not additional rent in any way. I'd like to move on now to.
Oh, sorry, just so I can understand. I think I understand it. There's 4 invoices that you refer to in paragraph 40 of your skeleton.
Correct.
Were they all for the outage period or not?
The 4 invoices yes, they all fall under the overall rental period. However, 2 of them relate to a time when there was no actual consumption. The system was shut off, but the claimant would still be entitled to rent pursuant to provision 8G1 under the heading of outage.
So in other words, there's no duplication at all, is there? Is that correct?
Correct.
So,
there's no duplication.
Two of the invoices relate to periods when there was no outage, and 2 relate to periods when there was outage. Is that correct?
Correct. So the outage period was from the 21st of March until the 8th of June 2024. So that is outage, and the other invoices relate to periods of actual usage. And if I would like to take Your Honor to page 1 second, Your Honor, I'm sorry. Yeah, I just wanted to take Your Honor through to the email that has that under which or in which we were informed of the outage. If you just give me 1 second, I'm trying to find the reference.
That's all right. Take your time.
Yes, so it starts at 575. If I can go to that document, please.
Yes, I have it.
Yes. So it starts at 575, and then if we scroll down to 578, so we will see here a chain of emails. So it actually starts at 579. That's the first email notification of the outage. So on 579, we can see here, this is an email from the first defendant to the claimant, which says, "Greetings, DEWA has disconnected our power temporarily. Kindly arrange to isolate the power from your side until such time that our 11 kV supply is restored. We will keep you informed." And then
Yep.
and then at 576, we see another email, which is dated on the 7th of June 2024, which says, "Greetings, DEWA has reconnected the power and you can deploy the team to reconnect the solar system." So in simple terms, we say that it is plain on the face of these emails that there was a period of outage and we were entitled to charge outage rent for that period of time.
I understand.
Thank you. The next issue is whether, pursuant to the agreement and the amendment agreement, the first defendant is liable for the consideration invoices. Now, we've seen the amendment agreement, and the amendment agreement, we say, is straightforward in the sense that it adds another obligation to make payment of the 1.6 odd million dirhams. And if we go back to page 217 of the bundle, we will see, does everyone have that?
Yeah.
Thank you. So we will see here in clause 1A, it says, "In consideration for lessor's payment of the waterproofing works under the tripartite agreement, lessee shall pay to lessor a total amount of 1.667 million dirhams, being the total waterproofing charges." And then a payment plan was agreed for payment of 51,298 per month. Now, in the following clause, in C, we see an addition of another event of default under the lease agreement, and it reads as follows. Yes. So on the face of this document, it is clear that we have two components. We have the first component being the obligation to pay the 1.6 million, which if the installment plan is not complied with, then becomes due in its entirety. And then we have a second component, which is the default payment. So the default payment kicks in if there is a failure to pay the consideration. And
that's I understand that. I think you say, do you, the default payment kicks in because of a contravention, if I can call it that, of clause 1B of the amendment agreement. There's an unresolved issue during the warranty period.
There are two limps to this. So there's the consideration payment, which is the 1.667, that is a standalone obligation that is not affected by anything. Now, the argument that is based on B touches on a separate issue, which is interest. So we say that the default payment is due regardless of the interpretation of section B, because already under the because to understand this correctly, we have to go back to the main clause under the lease agreement. And perhaps if we go back to that page, it will help put both of us into the right context. So that
Yes.
yeah, I'm bringing.
Sorry.
So we're going back to the main lease, and
Yeah.
and that's at page 72 of the bundle.
Yep.
So if we look at the clause that says lessee default. So this is the clause that refers to the purchase price payments, and then
sorry, let's see default. This is in the original lease, isn't it?
correct. That is under the original lease. But if we go to page 44 of the bundle, that's the general default remedies and damages clause. So this provision, Your Honor, is the provision that the amendment sought to amend.
Oh, that's that one, is it? But the amendment, as I understand it, is the amendment on page 93, Roman 9.
93.
The amendment agreement?
No, yes, correct. So the amendment agreement amends clause 13 of the lease agreement. So
Yep.
what I wanted to show, Your Honor, was clause 13 itself of the main agreement, which is on page 44 of the bundle.
Understand that.
Yeah. So
the only thing that I'm puzzled by is looking at the amendment itself. In respect of the tripartite agreement, there is a delay in performing the contract work to an unresolved defects liability issue, or C, unresolved issue during the warranty period. Now, that only relates to the tripartite agreement. There was no default. There was no problems arising under the tripartite agreement. That's why I have some difficulty in providing a 13A. The amendment gets you there in relation to the default provision.
so I'll explain our position. So the amendment agreement, this clause, you're absolutely right. It relates to only payments that are due under the tripartite agreement, which is the consideration, now having been called the consideration under the amendment. Right. So the express provision in B, in 1B, so which has become 13A, 13A9, it starts with in respect of the tripartite agreement, which means only the consideration for the waterproofing. And then if we read C, it says in the event of the default event set out in section 13A9, which is the one we just saw. So reading the two together, it means that that the default payment concerns only a breach of the obligation to pay the consideration amount.
Sorry, could you just put that to me again?
So there's the consideration payment, which is the 1.667 million.
Understand that. Understand
Right.
that.
If there is a breach to pay that, then the default amount kicks in.
Why do you say that? Why do you say that's the case? That's what I'm interested in.
Because on the face of at the beginning of 218 of the bundle, we see section C, which has been inserted now into the main agreement. It says, in the event of the default event set out in section 13A9, the lessee default values for the year amended are amended and laid down as follows.
But what is the default? That's what puzzles me. What is the default event in 13A9 that's occurred?
We say that the default event is an unresolved issue, which is payment.
I understand the argument. The only thing that troubles me with it is the words in respect of the tripartite agreement, because there was no unresolved issue in respect of the tripartite agreement. Now, I certainly understand and the argument that the only way you can make any sense of this provision and the fault provision is to say it applies, but it's by no means clear on the words of the provision, is it, Mr. Bajma?
Well, I mean, the document is like any document; it requires some form of interpretation. However, we say that,
and it has to be interpreted in context.
But in light of the defenses that were put forward by the first defendant, and the first defendant basically only advanced the argument that this document is a standalone document.
What? I understand.
Thank you. So this, I think, touches on both the issues of what is the consideration payment and the default payment as well. I will move on now to the question of interest.
Just go for a second. The warranty period is the period in the tripartite agreement, isn't it?
That is correct.
16 years or something like that.
13, I believe. 15.
15, sorry.
Yes. Yeah, understand. Can I move on to the next issue?
Yeah.
Thank you. So the next issue is the interest, and we claim interest on every amount that is due under all of the three buckets. And we say that this is contractually entitled to the claimant. If can take it on to page 190 of the bundle.
Yep.
So we will see here at the top of the page, provision 4C, and then it reads as follows. Any invoice shall become payable by the lessee within 30 calendar days from the date of issuance of the invoice by the lessor. Any invoice amount that is not paid within 30 calendar days of its due date shall accrue interest at the annual rate of 6%, but not exceed the maximum rate permitted by law. So we say that it is plain on the face of this provision that any invoice, regardless of the origin of the amount in that invoice, is subject to the 6% interest.
What did the defendant say in answer to that?
The defendant's position is that in relation to the consideration and in relation to the purchase price, the interest cannot be applied because these are not amounts that constitute part of invoiced amounts. So in the defendant's position, as I understand it, is that the word invoice should only apply to rent as opposed to purchase. That we say that any amount that is due can only be demanded by way of an invoice, and therefore it falls squarely under the definition of provision 4C.
I understand. I understand the argument.
Thank you. Now, the next issue is whether the claimant is entitled to the purchase price element of the claim. And on this point, I'd like to take your honor to page 195 of the bundle.
Yeah.
So if we look at the,
and you say you're entitled to the 6,482,000 dirhams, the year two amount.
Correct, because the default happened in year 2, so it's again plain and simple.
Understand.
Yes. There was an argument that was put forward by the first defendant, which contends that the purchase price element is a penalty clause, and that as a penalty clause, it should be unenforceable under English law principles. Now, our response to this is twofold. Number one, as I explained, we take the position that English law principles cannot be applied in this context because the IFC law and authorities themselves do not have the same principle with regards to the enforceability of penalty clauses. Secondly, on the merits of the argument itself, we say that in any event, the purchase price element cannot be a penalty because it provides for consideration for the transfer of title of the system itself. It's not that the amount is being charged without a value being transferred to the first defendant, because it is a mechanism that is meant to protect the investment of the claimant into the system in the event of default. So in essence, the defendant will end up being the owner of the entire system in lieu of this payment. So it is not a penalty in that sense. The other element is the other argument that was advanced by the first defendant is that pursuant to Article 21 of the DIFC law of obligations, the court should exercise its discretion to stop the enforcement of this clause on the basis of it being proportionally or it being manifestly disproportionate to the breach. And in response to this, we say that the first defendant's position is misconceived because firstly, the payment is not of a penalty. Secondly, the only argument that is relied upon by the first defendant is that the value, the purchase price value that is set out in this part of the agreement is higher than the value that would have been applied had the first defendant elected to voluntarily purchase the system. And we say that this is completely irrelevant because this is an agreement that was negotiated between two capable commercial parties who were privy to all types of technical and legal advice at the time of negotiating the contract. And therefore, the difference is meant to cover a real commercial bargain between the parties, in the sense that the claimant enters into a lease agreement in anticipation of it being complied with for its entire duration and it deriving the income for the entire duration. So in circumstances where we have a breach, it is common for any supplier to be compensated by way of a slight markup on the purchase price. So these are all commercial arrangements that were negotiated and agreed, and there is no disproportionality whatsoever.
Can I ask you a couple of things? Do you agree, or what's your submission on whether the payment, if I can call it that, falls within Article 21 of the Law of Damages and Remedies?
The purchase price payment.
Yeah.
Yes, we accept that it is covered by the ambit of this article. However, we say that it is not a situation where the court should exercise its discretion.
Secondly, would you agree that it would be the onus of, secondly, do you agree that the court would assess whether it's manifestly disproportionate at the time the contract was entered into, as distinct from the time that the breach occurred?
That's correct.
And third, would you submit that the onus of showing it's manifestly disproportionate is on the defendant?
That is correct.
Fourth, the defendant simply hasn't done so.
Yes, that is what we state in our skeleton as well.
Understand. Yeah. It's a more interesting question whether it's in fact a penalty under the English common law as distinct from this provision. Anyway, that's fortunately not for today.
Yes.
Yeah.
Right. The last issue that we have to look into, Your Honor, is the VAT. So the claimant has charged VAT as it is required to do so by law on all invoices that were issued to the first defendant. Now, the first defendant advanced an argument to the effect that it shouldn't be charged VAT, and the defendant's argument is based on two elements. The first element is the reliance on provision 4D of Exhibit 4 of the agreement, which is on page 158 of the bundle.
Yep.
So the first defendant relies on the provision titled C. So it says any invoice shall become payable. No, sorry, it's D. It starts with taxes. It is D, yes. So it says lessee shall pay or reimburse lessor for any and all taxes assessed on the lease of the system, the delivery or consumption of electric energy produced by the system, or the in-connection of the system to the utility. And then in the following paragraph, it says taxes means any tax, charge, imposit, and so on. So the first defendant's argument is that pursuant to this provision, taxes can only be charged on rent invoices, essentially.
Yeah.
So, and we say that this is wrong, because this provision is meant to address the operational element of the contractual relationship, However, there is another provision which addresses taxes in general, which is clause 13B2, which is on page 195 of the bundle. So in essence, we're saying, yes, D contains that wording, but that refers only to the operational part. And then
I understand.
yes, and then it says, because in on 195 we see clear wording, all accrued but unpaid rent, taxes, and so on. So this is a catch-all provision. The second argument relied on by the first defendant is a reliance on Article 27(1) of the VAT implementing regulations, which is a cabinet decision number 52 of 2017 of the UAE federal government. We can see that on page 643 of the bundle. So essentially, the first defendant argues that by way of this provision, if a price is not said to exclude VAT, then it should be deemed to be inclusive of it. That's the basic premise of that argument. And we say that this is wrong because if one looks at Article 27 itself, it says, it starts with, in case of taxable supply, the advertised prices shall be inclusive of taxes. So this is a provision that is supposed to deal with advertisements, not contractual provisions. And therefore we say it is completely irrelevant in this context. The second argument that we also provide in response to this point is that in 27(2)B, we have an exception. So it says, as an exception of clause 1 above, the taxable person may declare prices as being exclusive of tax in the following cases. And then B, it says, where the customer is a registrant, which is another tax person. So in this situation, the first defendant is also a registrant under the VAT system, and therefore, in any event, this.
So where do I find that?
So this is page 194 of the bundle.
Oh, I've got it. Thank you. Yeah, I've got it.
Right. So this brings me to the end of my submissions with regards to the skeleton. Before I end, I would like to address Your Honor on the calculation of interest, because it can get a bit confusing, because our position is that interest should be calculated from the due date, or 30 calendar days after the expiry of the due date of each invoice, and that is 30 days from the date of the invoice. We also claim interest to be applied on accrual basis, i.e. from 30 days from the due date up to the actual date of payment. So this means that the calculations we've provided the court until today were calculations that were up to the date of each relevant submission, with the most recent being the date of the skeleton itself. But obviously the meter keeps ticking on interest. So what I would like to propose is that if the court agrees to grant us the interest element on any of our heads of claim, then that the wording of the order should encompass the accrual basis of the interest.
What I think I'll do, Mr. Marshmallow, if this is convenient. No, I'm not going to give judgment this afternoon or this morning, whatever. I want to think about a couple of aspects. But it's fairly clear that you're going to be entitled to some, if not all, of the amounts you claim, together with interest. I'll set out the principles reasonably clearly and probably indicate that I adopt the approach you've taken in your very helpful schedules, and leave you to provide a document giving interest up to the date of the judgment.
Yes, this would be perfect, because if the order refers to the formula that we've provided to Your Honor, then that would make it easy for any enforcement officer to then calculate the interest by reference to that. This is what we intended. So yes, this brings me to the end of my submissions for today. I'm happy to answer any further questions.
No, thank you. It's been most helpful. I'll get a judgment as soon as I can, and hopefully within the next 2 to 3 weeks.
Thank you very much, Your Honor.
Thank you, Mr. Marshmallow. Yes, I'll adjourn now.
Thank you.